Welcome to Trust's Wills and Wealth Podcast, protecting what you've built and planning for what matters.
Welcome back to the Trust, Wills, and Wealth Podcast, protecting what you've built and planning for what matters with Isaac Cohen, the podcast where we break down complex estate planning topics into clear, practical guidance for California families. Isaac is the founder of the Cohen Firm, where he helps individuals protect their assets, their families, and their futures. I'm Evan Mack, and today Isaac will break down one of the most common estate planning tools in California, the Revocable Living Trust. He will talk about who actually needs a trust, how it works, and why so many Californians use it to avoid probate to maintain privacy. Mr. Cohen, welcome back, sir.
Thank you very much, Evan. It's good to see you again.
So let's get to the topic of what exactly is a Revocable Living Trust? How is it different from a will in California?
Great question to start with. So a will is basically a letter that somebody writes to a judge, and he says, "Dear judge, after I die, this is basically what I would like to happen to my property." The problem is the will itself doesn't own anything, so the judge has to get involved. The judge has to set up what's called probate. It's a court process where it will, under its own rules, based on its own factors, decide who gets your property under what circumstances after all these procedural requirements are met. A trust is a contract. It's different than the will, and I compare it to a suitcase. While you are living, you're carrying that suitcase, that trust, and that suitcase gets filled with your property. It owns your property. And after you pass away, you have already set up what's known as a successor trustee. You're the trustee when you're living, you're carrying that suitcase around. But when you pass away, your successor trustee takes that handle for the suitcase and then opens it up. It is full of your property, what you put into the trust. And that successor trustee, without having to go to court, without having to talk to the judge, in a matter of weeks, is able to transfer the property, distribute your property in the way that you stated in the trust that you, and not the court, decided you want your property to be distributed.
I see. So how does the Revocable Living Trust work while you're alive and then as opposed to after you pass away?
Very good question again. So while you are living, I'll use another analogy. So we talked about a suitcase at first. Let's talk about an app on your phone. While you are living, think about that trust as an app on the phone that's very important to the function of your phone, but you don't see it working. It's there doing its job, but you don't see it, you don't feel it. So as you go about your daily life, you are in control of your assets, just like you would if you didn't have the trust. You're the trustee. You control your assets. You're in possession of your assets. If you own a home, if you own property, you can sell that home. You can refinance that home. You can buy more property. Again, in that suitcase analogy, fill it up with more property. So during your lifetime, you are going about your normal daily tasks, enjoying your life, hopefully, and knowing that once you pass, you have set up that control mechanism so that you are going to dictate what happens to that property, where it's going to go, and you're going to keep the court and the state out of your business, basically.
So in your opinion, who actually needs a revocable living trust and who maybe might not?
If you ask me, I think everyone should have one.
Okay.
It's a pretty clear-cut question. Who should have a trust? Anybody that has an estate, okay, meaning their property, that's worth, I think the threshold now is just about a little over $184,000. So anybody that owns any property in California, just about the way our property values are, will need a living trust because the values are, on average, quite above that. And we're not talking equity, not equity in a property. So if you have a house that's worth $500,000 and you owe $400,000 to the bank, the state considers that $500,000, and you are now going to probate unless you have a trust in place to keep you outside of probate.
So is a living trust only for wealthy people, or does it make sense for maybe the middle class, the average families as well?
Well, you bring up a very popular misconception among most of us. Um, Most people think, yeah, it's the wealthy that need trust. It's the wealthy that form trust, and it's true. Wealthy people will use trust, revocable trust, irrevocable trust, to save taxes. There are vehicles that they can set up these types of trusts, and they will end up paying less taxes. That's all fine and good. But for everybody else, we need that to avoid probate. And probate is where it hits, the average family more than anything. So let's assume somebody has, and let's just talk about a house. In California now, we know what the values are. So let's say that they have a house worth about $700,000. It doesn't matter what they owe to the bank, whether they owe a penny or $600,000 to the bank. As far as the state is concerned, again, they look at the gross value. So 700,000, they're going to probate. And there's going to be probate fees. There's going to be attorney's fees, and those fees are set by law. The judge, basically just looks at a schedule, sees how much property is going into probate, and here's what the fee schedule is. For a $700,000 house, you're talking $30,000-$40,000 probably in fees, and that gets paid off the top. That gets paid, before any money goes to children, to spouses, to other beneficiaries. So it hurts, I would say, an average family to pay that $30,000 or $40,000 much more than it would hurt a multimillionaire family, a very wealthy family, to pay that same equivalent. So no, I'm getting back to your question, and the answer is the average person, I think, benefits much more from a trust, from a revocable trust, to save on what we call that probate tax, those fees in probate, to put them in control of who gets their assets, keep their estate out of the court system, which often lasts 12 months, 18 months, 24 months, and just to allow their family to get on with their lives.
But if someone already has a will, though, Mr. Cohen, why might you still recommend that trust, that living trust?
Okay, so a will is a good start. Again, a will is that letter to the judge saying, here's what I would like my property, how I would like my property to be distributed. So it automatically would tell me this is somebody that wants control, that wants to be in charge, that doesn't want to leave everything to chance, basically, to what the court is going to decide is the best use of your property, and who's going to get that property. So that's the first step. The second step is get the court out of it. Don't waste the time of your family. Don't waste your family's time. Don't waste your family's money. And you decide exactly how your property is supposed to be divided, how your property is supposed to go. If there are going to be any conditions, let's say you have a child that you don't believe should be getting property until he or she is 30 years old. Well, if you have a trust, you put that condition, and your trustee is going to hold and manage that property for you until your child, reaches that age specified in your trust. In this case, 30 years old, and really, again, puts the average person in the driver's seat as to what's going to happen to the property, to everything that they've built up in their lifetime. Rather than leave it to a judge that doesn't know you, doesn't know your family, doesn't know the needs, and just says, well, let's look what the schedule says. Let's look at, who's next in line. They're going to get it. And that's all. So a will is a good start, but it's not the whole plan.
Mr. Cohen, if someone owns a home in California, will Revocable Living Trust automatically protect that asset, or is there something else they have to do?
Great question. So the answer is yes, however. It's the starting point, or yes, you need the trust. Once the trust is set up, the purpose of the trust is to protect your home, is to keep it out of probate, is to put you in control as to who gets it under what circumstances. But it's not automatic. And I think you asked me if it would be automatic. So no, what has to happen? The trust has to be funded. That's the key here. You must fund a trust. What does that mean? It means the title to that house has to be changed. So let's say, John and Mary Smith own it as husband and wife as community property, or they own it as joint tenants, and that's all well and good. However, in order to have the protection of the trust, title must be changed. That title must go from John and Mary Smith to the Smith Family Trust, or John and Mary Smith, the trustees of the trust. And until that's recorded, until that's done properly, that real estate, that home is still outside the trust. And if John and Mary, when they pass away, unfortunately, guess what? The court has another case to administer in probate.
I'm sure you see this a lot, but what happens if someone sets up a trust but never transfers assets into it?
Yeah, we see it, unfortunately, all too many times. And nowadays, there's so many of these do-it-yourself estate plan websites and things like that, where you can just go ahead and basically, write up your own document and say, okay, I'm done. Well, no. So again, if the trust, assuming the trust is properly set up to begin with, and if it's not funded, think about it as if somebody goes to, somebody with a nice jewelry collection goes and sets up a safe deposit box in the bank. They want to keep their jewels protected. They get a safety deposit box. Fantastic. But what do? They leave their jewels on the kitchen counter. Well, you're halfway there. You've set up the means to protect your assets, but you're not actually protecting them. Those jewels, in my example, are completely open to theft, loss, whatever it's going to be. So same thing with the trust. We see this many times where people will set up a trust, even through attorneys. They'll go ahead and set up proper, well-drafted trust, but never take that final step. And that's a crucial step to fund the trust. Transfer title to your home into that trust. Transfer your bank accounts, those account names, to the trust. Make sure that everything is in the name of the trust, or it's outside the trust. It's outside of the protection of the trust, and it's just waiting to go through probate.
Well, Mr. Cohen, how does a revocable living trust help if you've become incapacitated, diminished capacity?
Oh, yeah, also a very good question. So that's why we call a revocable living trust. That's where the living part, comes in. You set up through the trust the mechanisms to cover that circumstance where something happens, somebody's legally incapacitated, somebody is not able to make his or her own decisions. Well, you have successor trustees in place, people that you decide, not the court, but you've decided this is somebody that I would trust these important decisions to. This is somebody that I would trust, the care of my kids or the welfare of my family to. And your trust is going to specify in this, in this case, here is what's supposed to happen. Successor trustee, you come in, these are your powers, this is what you're able to do. And there is no gap. There is no point in which your affairs aren't being tended to, decisions aren't being made, and care isn't being given to, let's say, minor children. So living trust says you're in charge, you're in control. But if you're no longer able to exercise that control, well, here's who you've decided is going to step in and make sure that your family's welfare is taken care of.
And before we go, what are the biggest mistakes you see people make when it comes to creating that living trust in the state of California?
We touched upon this just now, is taking the time, setting up a trust, doing everything that needs to be done, and then not funding it. Not funding a trust is the worst mistake, and it's the most common mistake that people can make. Where they think that they're protected, they think that they've done what they need to do to make sure that that next generation, the kids are going to be taken care of, that their money is not going to be wasted through probate, that they're going to be the ones that are calling the shots as to what happens to the property. And in the end, that doesn't happen. Why? Because they didn't take that final step. They didn't take that crucial step of saying, okay, it's not enough that we created the document, that we created this agreement. It's now time to fill the suitcase. As I said at the beginning, you need to make sure that your assets, whether it's real estate, whether it's vehicles, personal property, investment accounts, checking and savings accounts, those need to be titled under the name of your trust. If they are not in your trust, the court just has another case waiting for it after you pass.
Wow. Mr. Cohen, appreciate your time.
It's a pleasure. Thank you, Evan.
Pleasure's all mine, guys. And thank you all for listening to this episode of Trust, Wills, and Wealth Podcast, protecting what you've built and planning for what matters. If you want to learn more about Revocable Trust, visit thecohenfirm.com. Don't forget to like, subscribe, and share this episode as well. Thank you so much for listening, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.